Hello everybody, I'm delighted to be here with you today to continue our discussion of cryptocurrency regulation. Today's webinar is the third of 7 webinars I'm giving on crypto regulation in Hong Kong and how and in what ways this compares to crypto regulation in other jurisdictions. Today I'll be carrying on with a detailed discussion of Hong Kong's crypto regulatory regime, in particular the treatment of ICOs, STOs, and virtual asset exchanges, which will involve an analysis of key definitions, the extent of the SFC's regulatory reach and licensing, and other requirements where activities are regulated. So firstly, ICOs. As I discussed in the previous webinar, the SFC published regulatory standards in November 2018, which apply to virtual asset portfolio managers and distributors of virtual asset funds. The SFC's November 2018 statements didn't, however, touch on ICOs. In September 2017, following China's crackdown on ICO issues, the SFC issued a statement adopting a pragmatic approach. That is, rather than banning ICOs outright, the SFC opted to determine their regulatory status on a case-by-case basis, depending on whether the ICO tokens carry rights equivalent to traditional securities. For example, if they carry rights similar to those provided by shares, such as a right to a portion of the issuing company's profits or surplus assets on winding up, or whether they have rights similar to debentures, such as a right to repayment of the purchase price, whether they're similar in nature to an interest in a collective investment scheme where the purchase price will be invested in assets or projects and any return will be distributed to the holders. In fact, very few cryptocurrencies have features similar to shares or debentures. There's a question mark as to whether cryptocurrencies can be considered interests in a collective investment scheme, particularly given the lack of Hong Kong case law on the definition in the Securities and Futures Ordinance of a collective investment scheme. The essential features of a CIS under the SFO are that it must involve an arrangement in respect of property, and property is very broadly defined. The participants don't have day-to-day control over the management of the property, even if they have the right to be consulted or to give directions about the management of the property. The property must be managed as a whole by or on behalf of the person operating the arrangements, and/or the participants' contributions and the profits or income are pooled. And the purpose of the arrangement should be to provide participants with profits, income, or other returns from the acquisition or management of the property. There haven't been any court decisions on the meaning of collective investment scheme in Hong Kong, and whether or not any particular ICO falls within the definition will depend on the facts and circumstances of the ICO, and ultimately it would be the court's interpretation of the statutory definition which would prevail. Most ICOs in Hong Kong, as elsewhere, have typically been structured as offers of utility tokens. These are tokens which give holders rights to access a product or service provided by the platform, either now or in the future. And the SFC's February 2018 statement suggested this is outside the scope of Hong Kong's securities legislation. The SFC noted that ICO issuers it had contacted either confirmed that their tokens didn't constitute securities or they ceased to offer tokens in Hong Kong. Crypto exchanges contacted by the SFC reportedly also confirmed that they only trade non-security tokens, or they ceased to sell tokens which could be securities. The SFC hasn't published the names of the relevant ICO issuers or provided any further guidance on the features of an ICO token which are likely in Hong Kong to render it a security. Despite writing to a number of ICO issuers asking for confirmation that their ICO tokens were not securities, the SFC has only put a stop to one ICO, Black Cell Technologies ICO, in March 2018, on the basis that the offering may have been a collective investment scheme. However, this may be regarded perhaps as an extreme case, since the tokens sold in the ICO were redeemable for equity shares in the ICO issuer, Blackcell. The SFC's regulatory action resulted from concerns that Blackcell had engaged in potential unauthorized advertising activities in contravention of Section 103 of the SFO and may have breached the SFO's licensing requirements, although it did not specify which regulated activity was involved. Blackcell stopped ICO transactions with Hong Kong investors and undertook not to establish or market any CIS except in compliance with the SFO. While Hong Kong saw a number of ICOs in 2017 and 2018, ICO activity in Hong Kong really tailed off and virtually ceased in 2019 and 2020, following repeated warnings from the SFC. The lack of activity may also be due to the lack of clarity as to the features of an ICO token, which would bring it within the definition of a security, which is also true in many other jurisdictions. As for security token offers, or STOs, which follow a similar process to ICOs, the SFC issued a statement on STOs on the 28th of March 2019, setting out the regulatory requirements applicable to STOs and reiterating the SFC's earlier warnings to the public of the potential risks involved in investing in digital assets. STOs emerged in 2017 with two STOs raising $22 million together and began to pick up in 2018 when there was a total of 28 STOs raising $442 million and 55 in 2019 raising $452 million. Security tokens were then heralded in some quarters as the next big megatrend in the blockchain revolution. However, this is yet to materialize, with some citing the lack of a secondary market for tokenized securities, an underdeveloped regulatory environment, and high upfront costs. However, while there hasn't been staggering growth, there has been steady growth. The value of the STO market is expected to grow from around $983 million in 2018 to $2.6 billion by 2023, particularly in view of the institutionalization of the digital asset ecosystem. At the same time, market exuberance for ICOs has waned since the ICO mania of 2017 and 2018, with the funding method somewhat losing its legitimacy owing to some frauds or operating in what could be considered regulatory grey areas. STOs can be differentiated from ICOs, however, as while ICOs sought to position themselves outside the securities regulatory framework, STOs are being used in some jurisdictions, in particular the US, to bring crypto assets within the regulatory net as a means to achieve regulatory certainty, which means greater certainty for fundraisers and investors alike. Despite this, STOs have not been popular in Hong Kong as yet, but the area is developing. Part of the reason is that even with the SFC's STO statement, it's still very uncertain how the Hong Kong regulatory framework applies to security token offerings, and more fundamentally as to the characteristics which make a cryptocurrency a security token in the first place. Another shortcoming is that the SFC's March 2019 statement, which sets out requirements for intermediaries which market and distribute STOs, does not adapt or explain the concept of intermediary in the context of STOs. Unlike typical securities offerings, digital token offerings are decentralized and operate without traditional intermediaries, such as brokers. The UK FCA's January 2019 consultation paper recognized this as one area where the use of distributed ledger technology potentially raises novel issues that need to be considered in determining how existing regulation applies to token offerings. The FCA uses the term issuers of tokens to cover a number of entities, including developers, designers, firms who issue tokens, and certain intermediaries, because of the difficulty of determining precisely who the issuer or issuers are. Since traditional intermediaries like securities brokers are not typically involved in the ICO and STO markets, the Hong Kong regulators need to consider how investor protection concerns can be met without overburdening token issuers and stifling the market. So what does the SFC consider to be a security token? The SFC describes security tokens as digital assets which have the features of traditional securities, including tokens which represent economic rights, such as a share of profits or revenue. So tokens which are essentially tokenized shares, for example, entitling holders to a share of profits in the form of a dividend or to participate in the distribution of the issuer's assets on winding up, will be a security token and therefore a security under Hong Kong law. Similarly, a token which has the features of a debt or liability owed by the issuer will be likely to be a debenture for the purposes of Hong Kong securities laws. According to the SFC's March 2019 statement, a token representing ownership of assets, such as gold or real estate, would also amount to a security token, although the SFC doesn't elaborate on why this should be the case. It may be alluding to what is essentially a tokenized real estate or gold fund, where money raised from a token offering is invested in gold or real estate on the understanding that token holders will receive a share of the future proceeds of the gold or real estate when sold at a profit. In that case, the tokens would be likely to constitute securities as interest in a collective investment scheme under the SFO. Alternatively, the SFC could be suggesting that tokens whose value or price is somehow linked to the value or price of an underlying commodity, such as gold or real property, constitute either regulated investment agreements or structured products under the SFO definitions. Structured products are defined broadly and include any product where all or part of the return of the amount due or both, or the settlement method is determined by reference to any one or more of the certain factors, such as changes in the price, value, or level, or within a range of securities, commodities, indices, property, interest rates, currency exchange rates, or futures contracts, or any combination or basket of these, or the occurrence or non-occurrence of any specified events other than an event relating only to the issuer and or the guarantor of the product. The SFC suggests that depending on how the tokens are structured, tokens representing an underlying asset could constitute structured products subject to Hong Kong securities laws. There's been no official guidance from the SFC on how it would regard stable coins that are pegged to the price of assets, such as gold or fiat currencies, whose value may appreciate or not. Unlike jurisdictions such as the United States, Hong Kong doesn't regulate commodities such as gold. It would therefore be less than logical for a token representing a commodity, which is more akin to a deposit slip than a security, to be regarded as a security, subject to Hong Kong's securities regulatory regime, or so one argument runs. The FSTB's November 2020 consultation paper proposing a licensing regime for exchanges trading non-security cryptocurrencies confirmed that cryptocurrencies that are backed by assets for the purpose of stabilizing their value are virtual assets for the purpose of the proposed new licensing regime. So an exchange trading stablecoins, which are not securities, would need to be licensed under the new AMLO licensing regime. A regulated investment agreement is an agreement the purpose or effect of which is to provide any party to the agreement a profit, income, or other return calculated by reference to changes in the value of the relevant property, for example, equity-linked deposits, but it doesn't include a collective investment scheme. Unless a security token offering is essentially a tokenized fund offering, which is a collective investment scheme, there seems to be little support for the SFC's statement that tokens representing digital ownership of assets such as gold or real estate constitute securities under the SFO, and further guidance on this from the SFC would be very helpful. So what are the regulatory implications of STOs being securities under the SFO? Well, the SFC's statement on STOs says that where an intermediary markets or distributes security tokens, they should only offer them to professional investors. An offer of security tokens only to professional investors as defined in the SFO has the advantage of being exempt from the requirement for SFC authorization of any advertisement or invitation issued in relation to an offer of securities, where the security tokens are offered to more than 50 people in Hong Kong. Where STO tokens amount to interests in a collective investment scheme, restricting the offer to professional investors will mean that the stringent requirements of the SFC's code on unit trusts and mutual funds wouldn't apply. Those requirements would be likely to make an STO unworkable, given the fact that the requirements for the appointment of a qualified fund manager and a custodian that's a bank or trust company registered under the trustee ordinance, and that the investment restrictions applicable to retail funds, which include a prohibition on real estate investment and a restriction on investing no more than 15% of the fund's net asset value in investment products that are not listed on the Hong Kong Stock Exchange or another recognized stock exchange. Where crypto assets are securities under the SFO, any exchange which provides trading in the security tokens and any intermediary which markets and distributes the security tokens has to be licensed or registered by the SFC for Type 1 regulated activity dealing in securities, and each of its staff members conducting trading or marketing of securities tokens also has to be licensed for Type 1. The SFC says in its March 2019 statement that security tokens should only be offered to professional investors. Intermediaries which market and distribute security tokens have to comply with the conduct provisions of the SFC's Code of Conduct for persons licensed by or registered with the SFC. In particular, the requirement under paragraph 5.2 to ensure that customer recommendations and solicitations with regard to security tokens are reasonably suitable for the particular customer, given the information about that particular customer which the intermediary is or should be aware of through their carrying out of due diligence. Intermediaries also have to refer to the SFC's suitability FAQs and FAQs on triggering the suitability obligations. Although these aren't referred to in the SFC statement, all licensed intermediaries are also under an obligation to conduct customer due diligence and anti-money laundering checks on their customers, and these apply irrespective of the type of product being recommended or the subject of a customer's solicitation. The SFC regards security tokens as complex products as defined under paragraph 5.5 of the Code of Conduct. Paragraph 5.5 imposes additional obligations on licensed intermediaries which make recommendations or solicit investors with regard to complex products. In particular, licensed intermediaries and their licensed staff are required to make sure that the security token is suitable for the client in all the circumstances, that the client is provided with sufficient information on the key nature, features, and risks of the security token to understand it before making an investment decision, and that the client is provided with clear warning statements about the security token's distribution. The SFC's March 2019 statement mentions the need for intermediaries who market or distribute security tokens to conduct proper due diligence on the offering, which should cover, amongst other things, the background and financial soundness of the management development team and the issuer of the security token, and the existence of and rights attached to the assets which are backing the security token. Licensed intermediaries are also required to study security tokens white papers and all relevant marketing materials and other published information. The March statement also notes that intermediaries' obligation to ensure that information provided to customers in respect of an STO is accurate and not misleading. This is the first time that the SFC has raised the issue of the standard of due diligence it expects in relation to securities token offerings and intermediaries' responsibility for the accuracy of information. Intermediaries should provide their customers with clear and comprehensible information on STOs, which should include prominent warning statements, alerting potential investors to the risks associated with digital assets. The SFC reminds licensed intermediaries to implement adequate systems and controls to ensure compliance with their regulatory obligations prior to engaging in security token distribution. The SFC also requires licensed intermediaries to notify it in advance prior to conducting any business in security tokens. A loophole in the SFC's regulatory approach to security token offerings, however, is that the investor protection-driven measures of the Code of Conduct, such as the obligation to ensure the suitability of investment products for individual clients, anti-money laundering and counter-terrorist financing obligations and so on, only apply where a traditional intermediary is involved. The Code of Conduct does not apply to issuers of securities, and so on a typical security token offering, there's no obligation on the issuer to ensure the accuracy of the information provided in its marketing documents, nor to assess the suitability of its tokens for prospective purchasers, other than general laws on misrepresentation and the general criminal law, of course. Add to this the fact that token issuers and their designers and developers are typically based offshore outside the regulatory remit of the SFC. Protection for Hong Kong investors against fraudulent or incompetent issuers is perhaps somewhat lacking. The SFC Code of Conduct requirements referred to in the SFC's March 2019 statement will only apply where a Hong Kong SFC licensed or registered intermediary is engaged to market the tokens to Hong Kong investors, a scenario which has not yet occurred in Hong Kong. However, as I'll discuss very shortly, if security tokens are to be traded on a Hong Kong crypto exchange, the operator of the exchange will need to be licensed, and so secondary market trading will be subject to SFC regulation. Under the SFO, security tokens, in the same way as traditional securities, can't be marketed to Hong Kong investors except by an SFC Type 1 licensed entity. However, if security tokens are not actively marketed to the Hong Kong public, there's nothing to prevent Hong Kong investors from subscribing for tokens through an offshore platform, and in this situation, none of the Code of Conduct's investor protection mechanisms will apply. Also, if the offering turns out to be a scam, Hong Kong investors have no immediate means of redress other than a contractual claim or common law or criminal law actions against the token issuer. Given that white papers generally don't even always set out the issuer's legal name and registered address, this route to recovering losses may not be straightforward. These issues are, of course, by no means unique to Hong Kong, and regulators worldwide face similar challenges. So, what about the regulation of virtual asset platform operators? Well, as with the regulatory approach set out in the November 2019 position paper, the SFC will regulate trading platforms operating in Hong Kong only if they trade at least one cryptocurrency, which is a security. Since the vast majority of cryptocurrencies are not securities, crypto exchanges which only trade cryptocurrencies that are not securities or futures contracts are not currently regulated. Indeed, the precondition that an exchange must trade at least one cryptocurrency, which is a security, that means it's a security token, makes most ineligible for licensing, even if they wanted to be licensed. More fundamentally, the SFC licensing framework applies only to centralized exchanges and not to decentralized exchanges on which investors trade on a peer-to-peer basis, and which have become increasingly popular. As for AML CFT legislation in Hong Kong, the Anti-Money Laundering and Counter-Terrorist Financing Ordinance currently only applies to financial institutions, including HKMA authorised institutions, that's banks, SFC licensed corporations, licensed insurance companies, stored value facility issuers and money service operators, and designated non-financial businesses and professions such as lawyers, accountants, estate agents, and trust and company service agents. Cryptocurrency exchanges which trade at least one security token are required to be licensed by the SFC and are subject to the AML and CTF obligations of the AMLO. Cryptocurrency exchanges that don't trade any security tokens and OTC desks are not currently required to be licensed and are not subject to the provisions of the AMLO. The Financial Secretary's 2020 to 2021 budget speech said that the Hong Kong government would consider extending the AML CFT requirements to cover cryptocurrency service providers. The FSTB published a consultation paper in November 2020 proposing a new licensing regime for virtual asset exchanges under the AMLO. The proposal, if adopted, would require any virtual asset exchanges operating in Hong Kong to obtain a VASP license from the SFC, a requirement which would apply even if the exchange only trades virtual assets which are not securities. And I'll be going into this proposal in more detail shortly. In relation to licensed crypto exchanges currently operating in Hong Kong, until recently there weren't any. It wasn't until the 16th of December 2020 that the SFC issued the first virtual asset trading platform license to OSL Digital Securities, a platform which will only provide services to professional investors, which is one of the licensing conditions. The platform will be subject to the SFC's close supervision and tailored requirements, similar to the requirements applicable to securities brokers and automated trading venues. That's the terms and conditions for virtual asset trading platform operators which will apply. So let's take a look at the licensing conditions that the SFC imposes on the operators of a licensed crypto exchange. First, the licensing conditions restrict the exchange to providing services only to professional investors as defined in the SFO, which includes high net worth investors under the Securities and Futures Professional Investor Rules, meaning that any exchange operating in Hong Kong which provides services to people other than professional investors can't qualify to be licensed, an approach which is narrower than that prescribed under the revised FATF recommendations. Secondly, the operator of the exchange has to obtain the SFC's approval before introducing or offering a new or incidental service or activity, making any change to an existing service or activity, or adding any product to its trading platform. Thirdly, licensed platform operators are required to provide the SFC with monthly reports on their business activities in the format prescribed by the SFC within 2 weeks after the end of each calendar month. Fourthly, licensed platform operators must engage an independent professional firm to conduct an annual review of their activities and prepare a report confirming compliance with the licensing conditions and all relevant legal and regulatory requirements. It's also a licensing condition that the licensed platform operator has to comply with the terms and conditions for virtual asset trading platform operators, which focus on the platform's operations. A breach of any of the licensing conditions will constitute misconduct under Part 9 of the SFO and may also reflect adversely on the fitness and properness of the platform operator to remain licensed. Looking at the terms and conditions which a licensed crypto exchange operator has to satisfy, these relate firstly to providing safe custody for cryptocurrencies. The SFC expects a licensee to adopt an appropriate operational structure and use technology to protect its clients, equivalent to those required of traditional institutions in the securities sector. Licensed platform operators have to hold client assets on trust to enhance safekeeping of client cryptocurrencies and ensure they are properly segregated from those of the platform operator. Any material legal uncertainties, particularly as to the nature of any legal claims they may have over cryptocurrencies traded by them on the platform, must be disclosed in full to clients. The SFC mandates that client assets must be held through a company which is incorporated in Hong Kong, which is a wholly owned subsidiary of the licensed platform operator and holds a trust or company service provider license under the AMLO. Interestingly, in Hong Kong, there's uncertainty as to whether cryptocurrencies constitute property under Hong Kong law, which may affect a client's rights in insolvency proceedings. Notwithstanding this, the SFC has said that this should not preclude the implementation of an interim regulatory regime. The SFC also requires the segregation of customers' virtual assets. Licensed platform operators have to store 98% of client cryptocurrencies in cold wallets. That's where the private keys are kept offline, and limit their holdings of client virtual assets in hot wallets. That's where private keys are kept online, rendering them vulnerable to external threats, to no more than 2%. Licensed platform operators also have to minimize transactions out of the cold wallet in which a majority of client cryptocurrencies are held. Platform operators are also required to have adequate processes in place for handling requests for deposits and withdrawals of client cryptocurrencies to guard against loss arising from theft, fraud, and other dishonest acts, professional misconduct, or omissions. The platform operator and its subsidiary holding the client's cryptocurrencies also have to set out in writing details of the mechanism for transferring cryptocurrencies between hot, cold, and other storage, and the procedures for dealing with events such as hard forks and airdrops from an operational and technical perspective. Licensed platform operators must have an insurance policy covering the risks associated with the custody of cryptocurrencies held in both hot storage, where they need full coverage, and cold storage, where they need a substantial coverage, which is in effect at all times. The SFC expects a licensed platform operator to set up and implement strong internal controls and governance procedures for private key management to ensure all cryptographic seeds and keys are securely generated, stored, and backed up. The SFC requires licensed platform operators to take all reasonable steps to establish the true and full identity of each of its clients and of each client's financial situation, investment experience, and investment objectives. Except for institutional and qualified corporate professional investors, as defined in the Code of Conduct, before providing any services to the client, a platform operator has to ensure that the client has sufficient knowledge of cryptocurrencies, including knowledge of the relevant risks associated with them. Where a client doesn't have that knowledge, services can only be provided to the client if the platform operator provides training to the client and inquires into the client's personal circumstances. Concentration risks are also required to be assessed by setting a trading limit, position limit, or both, by reference to the client's financial situation to ensure that the client has sufficient net worth to assume the risks and bear any potential trading losses. Licensed platform operators are required to establish and implement adequate and appropriate AML and CTF policies, procedures, and controls to counter the money laundering and terrorist financing risks perceived to be associated with cryptocurrencies' anonymity. Platform operators also have to regularly review the effectiveness of their AML and CTF systems and put in place appropriate enhancements, taking into account any new SFC guidance and updates to the FATF recommendations applicable to cryptocurrency-related activities, including the Recommendation 15 I've talked about before and its related interpretive note. Cryptocurrency tracking tools can also be used to trace transaction histories against a database of known addresses connected to criminal activities. So, prevention of market manipulation and abusive activities. Licensed platform operators are required to establish and implement written policies and controls for the proper surveillance of activities on their platform in order to identify, prevent, and report any market manipulative or abusive trading activities. They must also adopt an effective market surveillance system and provide the SFC access to this system to perform its own surveillance. Policies should be established for the proper surveillance of platform activities to identify, prevent, and report market manipulative or abusive trading practices or activities. Licensed platform operators are also required to exercise due skill, care, and diligence in selecting and appointing their auditors. Licensed trading platforms also have to have a risk management framework which enables them to identify, measure, monitor, and manage the full risks arising from their businesses and operations. Clients have to pre-fund their own accounts, as licensed platforms are not allowed to provide any financial accommodation for clients to acquire cryptocurrencies. Licensed platforms are prohibited from engaging in proprietary trading or market-making activities on a proprietary basis. If a platform plans to use market-making services to enhance liquidity in its market, this has to be done at arm's length and be provided by an independent external party using normal user access channels. A licensed platform operator must also have a policy governing employees dealing in cryptocurrencies to eliminate, avoid, manage, or disclose actual or potential conflicts of interest. Licensed platform operators are not allowed to offer or trade cryptocurrencies that are crypto futures contracts or crypto derivatives. Licensed platform operators have to set up a function responsible for establishing, implementing, and enforcing the rules, setting out the obligations of and restrictions on issuers of cryptocurrencies, and the criteria for a cryptocurrency to be included on and/or withdrawn from the platform. The platform operator is also obliged to conduct reasonable due diligence prior to including a cryptocurrency on its platform and must ensure that the cryptocurrencies traded on the platform continue to satisfy all of the application criteria. Matters which have to be considered include the background of the management team or development team of the issuer of the cryptocurrency, the regulatory status of the cryptocurrency in each jurisdiction in which the platform operator provides trading services, which includes whether the cryptocurrency can be traded under the SFO. Supply, demand, maturity, and liquidity of the cryptocurrency, its market cap, average daily trading volumes, whether other platform operators trade the cryptocurrency in question, the availability of trading pairs, and the jurisdictions where the cryptocurrency is being offered. The marketing materials of the cryptocurrency must not be misleading. The development and outcomes of any projects associated with a cryptocurrency should be included in the white paper, together with the major incidents associated with its history and development. In relation to cryptocurrencies which are securities under the SFO, the licensed platform operator should only include those which are asset-backed, approved by or registered with regulators in comparable jurisdictions, as agreed by the SFC from time to time, and have a track record of 12 months or more since issue. Whilst on the subject of trading cryptocurrencies, I'm also going to talk a little bit about Hong Kong's position in relation to virtual asset futures contracts. Generally, they're largely unregulated, highly leveraged, and subject to extreme price volatility. And this has led the SFC to issue a statement warning investors of the risks in November 2019. The SFC noted that trading platforms or people who offer and/or provide trading services in virtual assets futures contracts without being licensed under the SFO may be in breach of the SFO. Virtual asset futures contracts may also constitute contracts for differences under the gambling ordinance, which may not be legal unless authorized under that ordinance. Further, according to the SFC's circular on Bitcoin futures contracts and cryptocurrency-related investment products in December 2017, a Hong Kong entity which enables Hong Kong investors to trade Bitcoin futures contracts which are traded on the Chicago Mercantile Exchange or Chicago Board Options Exchange, including by relaying or routing orders for these Bitcoin futures contracts, will need to be licensed by the SFC for regulated activity type 2, which is dealing in futures contracts. As I mentioned, the FSTB published a consultation in November 2020 proposing a new licensing regime for virtual asset exchanges under the AMLO, which will require any person seeking to conduct the regulated VA activity of operating a virtual asset exchange in Hong Kong to obtain a VASP license from the SFC, even if the exchange only trades virtual assets which are not securities. The proposed regime aims to implement the Financial Action Task Force, FATF's requirement for jurisdictions to regulate virtual asset service providers for anti-money laundering and counter-terrorist financing purposes and supervise their compliance, a requirement introduced in February 2019 with the revision of FATF standards. The application of the proposed regime will, however, be much narrower than the FATF's definition of VASPs, which also covers businesses involved in transferring virtual assets, providing safekeeping and/or administrative services of virtual assets or instruments enabling control over virtual assets, including certain wallet providers, or providing financial services related to the offer or sale of virtual assets such as ICOs. This is because the FSTB considers virtual asset exchanges to be the most prevalent and developed virtual asset activity in Hong Kong, therefore warranting the introduction of a tailored licensing regime, with the potential for expansion of the regime at a later date. If the new licensing regime takes effect, virtual asset exchanges will have 180 days to obtain a VASP license. So what's the definition of a virtual asset exchange? Well, it will be defined as any trading platform which is operated for the purpose of allowing an offer or invitation to be made to buy or sell any virtual asset in exchange for any money or any virtual asset, whether of the same or a different type, and which comes into custody, control, power or possession of or over any money or any virtual asset at any point in time during its course of business. This definition will require centralized virtual asset exchanges to be licensed. However, peer-to-peer trading platforms, that's platforms that only provide a forum for buyers and sellers of virtual assets to post their bids with or without automated matching mechanisms, are excluded from the definition, provided that the actual transaction is conducted outside the platform and the platform isn't involved in the underlying transaction by coming into possession of any money or virtual asset at any time. Decentralized virtual asset exchanges should therefore fall outside the scope of the licensing regime. The proposals will largely align the definition of virtual assets with FATF's definition, that's digital representations of value that can be digitally traded or transferred and can be used for payment or investment purposes. The AMLO will define a virtual asset as a digital representation of value that is expressed as a unit of account or a store of economic value, functions or is intended to function as a medium of exchange accepted by the public as payment for goods or services or for the discharge of a debt or for investment purposes, and can be transferred, stored or traded electronically. The definition will therefore cover virtual assets which are not securities, such as Bitcoin and Ether. Stable coins, that's virtual assets backed by assets, will also fall within the definition. Digital representations of fiat currencies, including CBDCs, financial assets already regulated under the SFO, and closed-loop limited purpose items that are non-transferable, non-exchangeable and non-fungible, including air miles, credit card rewards, gift cards, customer loyalty programs and gaming coins, are excluded. Turning now to the requirements for licensing. First, eligibility. The FSTB is proposing that only Hong Kong incorporated companies with a permanent place of business in Hong Kong will be eligible for licensing as a virtual asset exchange. So natural persons, that's individuals, and businesses without a separate legal personality, such as sole traders or partnerships, can't be licensed. Virtual asset exchanges that are incorporated offshore will also not be eligible for licensing under the new regime. The FSTB also proposes to prohibit the active marketing of a regulated VA activity or similar activity, that's services associated with a virtual asset exchange, whether in Hong Kong or elsewhere, to the public in Hong Kong without a VASP license. This provision is similar to Section 115 of the SFO, and since the SFC will not license an offshore entity, this will effectively prevent an offshore virtual asset exchange from marketing its services to Hong Kong investors. An offshore exchange that wants to be able to market to Hong Kong investors will therefore need to establish a Hong Kong subsidiary, which will need to be licensed as a VASP by the SFC. Licensing applicants will be required to appoint at least 2 responsible officers who will be responsible for ensuring the firm's compliance with the AML/CTF requirements and other regulatory requirements. As is the case for licensed corporations, all executive officers will need to be approved as responsible officers of a licensed virtual asset exchange. The licensing applicant, its responsible officers, and the ultimate owners of the corporate entity will need to satisfy a fit and proper test, which will assess the person's experience and qualifications and require that they've not been convicted of any money laundering or terrorist financing offence or other offence involving dishonesty and are not the subject of any liquidation or bankruptcy proceedings. Any change to the responsible officers or ultimate owners will require the SFC's prior approval. However, the FSTB do not clarify who will be regarded as an ultimate owner of a virtual asset exchange for these purposes. Licensed virtual asset exchanges will be required to observe the AML/CTF requirements under Schedule 2 to the AMLO, which sets out certain requirements relating to customer due diligence and record keeping. The regulatory standards for virtual asset exchanges licensed under the AMLO will be essentially the same as those for exchanges licensed under the SFC's opt-in regime, to ensure a level playing field for all virtual asset exchanges. The SFC will be empowered to impose licensing conditions and other regulatory requirements and may vary them where appropriate. These will include restrictions on providing trading services to professional investors only, although the SFC may relax this position in the future as markets mature. A required minimum paid-up share capital requirement, depending on the nature of the business, a liquid asset requirement, again to be set by the FSTB. Licensed virtual asset exchanges will be required to have a proper corporate governance structure, staffed by personnel with appropriate knowledge and experience. Requirements relating to operating their virtual asset business in a prudent and sound manner, and ensuring that client and public interests are not adversely affected. Putting in place risk management policies and procedures for managing money laundering and terrorist financing, cybersecurity and other related risks. Ensuring the proper segregation of client assets and ensuring adequate policies and governance procedures are in place to ensure the proper management and custody of client assets. Implementing and enforcing robust rules for the listing and trading of virtual assets on their platforms. In particular, they will need to perform all reasonable due diligence on virtual assets before listing them for trading. Following specified auditing and disclosure requirements and publishing audited accounts. Implementing written policies and controls for the proper surveillance of activities on a virtual asset exchange, to identify, prevent and report any market manipulative or abusive trading activities, and avoiding any conflicts of interest. Licensed virtual asset exchanges will be prohibited from engaging in proprietary trading or market-making activities on a proprietary basis. The SFC will be empowered to supervise the AML-CTF conduct of licensed virtual asset exchanges and to monitor, investigate and enforce their other obligations under the AMLO licensing regime. The SFC will also be given certain powers in relation to entering and inspecting premises and documents in order to investigate instances of non-compliance, and will be empowered to impose administrative sanctions, including suspending or revoking a license. The SFC will also be provided with intervention powers to impose restrictions and prohibitions on the operations of a licensed exchange and its associated entities in certain circumstances. For example, where it's necessary to protect client assets. The FSTB also proposes to amend Part 6 of the AMLO in order to expand the scope of reviewable decisions of the AML-CTF Review Tribunal to cover appeals against future decisions made by the SFC in relation to implementing this vast licensing and supervisory regime. So thank you again for joining us today. As I mentioned earlier, this is part 3 of a 7-part webinar series. Part 4 will be held on Friday, the 29th of January, and will conclude the discussion of crypto regulation in Hong Kong, and I'll begin a comparative analysis with regulation in other jurisdictions. You are most welcome to join us. You can find the link to register on our website. For those of you who have already registered, I look forward to seeing you next Friday, and have a great weekend.